So today we will be answering the question, where does the words or the decrees or orders of the Supreme Court gets their power from? In this, we are saying that you have heard earlier, or that you have heard, I guess, that in XYZ case, Supreme Court has said this and this is the law of the land. And the question arises that even though Supreme Court is not an elected body, then how does it get to make laws or has anything that has the power of law to be imposed upon us? Well, the answer lies in Article 142. That is, that it is a constitutional power, which would mean that it is the wisdom of our founding fathers that have given Supreme Court such a wide and very strong power. What does Article 142 says? Article 142 says that the decrees and order of Supreme Court, which are necessary for doing complete justice. We will get to what complete justice means later, but it is a very important concept as well. Complete justice shall be enforceable throughout the territory of India. Shall be enforceable throughout the territory of India. Right here. So clearly, Article 142 says this, but it also places a bound which says subject to provisions of any law made in this behalf by Parliament. So to obviate this need, they have also made a constitutional order, Constitutional Order 14, which actually enforces it or activates this article. You can see it right here, the legislative.gov.in Vidhey Vibhag, and Vidhey Vibhag's PDF basically gives us that Constitutional Order number 14 is for Supreme Court decrees and orders and basically enforces Article 142. You can see it for yourself. There is not that it is not that deep, basically. Now, what is the significance of Article 142? The second question that must come in our minds. Significance is that Article 142 forms the basis of judicial activism that Supreme Court has been showing for as long as it has been in existence. Article 142 actually tells us what the founding fathers envisioned Supreme Court to do. They wanted it to provide complete justice, as it says right here. As it says right here, they wanted it to provide complete justice to the people of India. And so they formed Article 142, which gives it enough discretion to actually do what it's supposed to do. There are many landmark cases that would further shine this point and bring the significance into the light. The cases of Ayodhya case, Union Carbide case, ban on sale of alcohol near highways are some, not all, but some of the cases that have compelled Supreme Court to use Article 142. Now, the Article 142 has huge powers. The scope is very large. And what is the limitations? That is the third question that comes into mind. The limitations are basically given by two cases, Premchand case and Union Carbide case, and it is nicely encapsulated by Supreme Court Bar Association case, but at the end of the day, the limitations are blurry. There are no strict guidelines, no statutory law, only a constitutional order that just enforces the article, nothing else. But we have what we have here. So this little schematic diagram will help you understand that there are two cases, Premchand case, which basically says that the scope of Article 142 is up till, or it ends where statutory provisions are provided. That means that Article 142 does have wide scope, but wherever statutory provisions are there, they have to follow that by the letter. But Union Carbide says no. The complete justice phrase completely obviates the need to toe the line of the statutory provisions that have been provided in the parliamentary laws. That would mean that Article 142 is greater than or equal to the law of the land that was made by the legislatures. Now, Supreme Court Bar Association case says that prima facie, it would seem that Union Carbide case is in contrast to Premchand case or is in paradoxical position as compared to Premchand case, but that is not so. Union Carbide case does say that in pursuance of complete justice, a Supreme Court can uh, jump the line between the line that has the boundary that has been drawn by the law in order to provide complete justice. But it cannot ignore the statutory provisions, and the discretion that is provided to Supreme Court must be used with caution. And statutory provisions, as I said earlier, cannot be ignored. So that is roughly what has been told to us by the Supreme Court with what Article 140 is supposed to do, but the strict guidelines are not there. So the limitations are blurry. Now to the important question of what is complete justice. The definition of complete justice, and I have taken it from Dr. Justice B.S. Chauhan, who has been a Supreme Court judge. So his word is better than most, I would say. And he just gives you can read this article, it is on nj.nic.in. But the essence is that complete justice means justice for all. What does justice mean? Complete justice means that recognition, protection, and enforcement of rights and liberties. That is, that people get their just dues. Nobody is denied that. And if such rights are violated, such rights are denied, then there exists a remedy. That is the enforcement part. So that is what justice is. It does not concern itself with providing a morality of actions. It just concerns itself with providing that the persons involved within the jurisdiction of the court get their dues that are just, right? That is where the word comes from. Just means rights. Now, complete justice means justice for all. Who are all? All means the parties that are involved in the dispute as well as the larger public interest. So it is a very large phrase. Founding fathers did not just use the word justice, but they specifically used the word complete justice to hammer home this argument. Article 142's draft was passed without any debate in the Constituent Assembly proceedings. That would completely say that there was a general agreement between our founding fathers that such wide power with the phrase complete justice was indeed needed for Supreme Court to act as a supervisor of justice in the country of India, that is Bharat. What complete justice is. In conclusion, the founding fathers envisioned Supreme Court to be like a father figure that would see that the people of our country are getting the justice they deserve. Nobody is getting injustice and nobody's justice is being denied. And Article 142 serves that purpose and serves that vision of our founding fathers. Thank you. Like and subscribe.